here for part 2 of Renters 101? Harrison, can you hear me in the back there? I can, just fine. Okay. So, hopefully, some of you have continued from part 1.
The tech guy says to speak a little louder. Oh, bring the mic closer to him.
Okay. All right, if anyone was not here for part 1 and has not received a booklet, flag down Harrison or Sean. They'll give you a booklet. We have some extras in the back. There's going to be another evaluation for this section. At the end, if you're here for your continuing education credits, because you're a real estate professional, we're going to need you to sign out at the end. And there will be, I believe that there will be certifications printed on site, but I know that we already have the sign-up sheet ready to go. So this portion is going to be similar to the beginning, just a continuation. Again, just a reminder, questions about the law, questions about to clarify what we're telling you, perfectly fine. If it's about your individualized topic or something that you've personally experienced, please go to the legal clinic or possibly follow up with either OTA, or if you're a real estate professional on behalf of a landlord, then the Housing Provider Ombudsman is a resource that's available as well. So coming up, we're going to touch on, Ramona's going to go through housing code as well as tenant rights to address repairs as well as evictions. And then I'm going to close out with some of a little bit more real estate professional based stuff when it comes to TOPA, condominium conversions, and retaliation. Right, exactly, another important one. So thank you all for attending. For those of you who just came in, flag down one of the gentlemen wearing ties in the back if you need a new booklet, and they'll get you one, and we're ready to go. And this is Ramona Quillette, an attorney advisor for the Office of the Tenant Advocate. She's been there for 5 years, and she's going to tell you about housing code issues.
Hello, everyone. Hello. All right, we're going to start with sound. Can everybody hear me? Yes. Fantabulous. All right, so the first thing I want to talk about is the housing code. The DC Housing Code sets a floor. That's saying this is the minimum that that we need to have the housing conditions for us to have tenants. That's really all it is. So your DC Housing Code is not going to say what type of fridge you should have, whether there needs to be a dishwasher, that sort of thing. They're really saying no holes in the wall. The floor should be the floor shouldn't have holes. If there's carpet, the carpet should be without holes, like that sort of thing. So your windows shouldn't be broken. They ask that you have window screens if you have windows, but that's neither here nor there. So there's an implied warranty of habitability. Habitability? That word is always hard.
Habitability?
Thank you. So there's this implied warranty in every lease in the district. So whether it has these specific words or not, every lease in the district has this implied warranty that the house is up to the standards of the housing code. The landlord has the duty to maintain all common areas in the building and the unit. So this comes into, there are some questions about what you do in the lease. So some leases will say tenants are responsible for these certain types of repairs. And what that basically means is the tenant ultimately would have to pay for the repair, but the landlord still has the duty to maintain the house. So if there's something broken, the tenant can call DCRA to request a housing code inspection. It's free. DCRA would then cite the landlord for any visible housing code inspections, or housing code violations. They do not go into walls, they do not pull up carpet, but if they can see it, they can cite it. And the tenant also has an option of going to DC Superior Court, because there's a special branch of DC Superior Court Civil Actions Branch that only handles housing code violations. It's sometimes called fix-it court. They don't really do money, but what they'll do is cite there's a judge who's ordering the landlord to make the necessary repairs, and the landlord and the tenant will just have to keep coming to court until the repairs are made. And if the judge believes that the landlord is like unduly delaying or is not acting in good faith, the judge has the authority to, as a punishment, tell the tenant that they don't have to pay rent. And they'll say, you don't have to pay rent until the repair is made. So that's not a place that anyone wants to be, but for tenants, it's a really strong protection to know that you can get a free housing code inspection from DCRA, and if you have to, you can take your landlord to court and there's a court where the judge is on the side of the housing code. Like, the judge isn't pro-tenant or like anti-landlord or anything like that. They just say, this is the housing code, this is the standard. If you're renting in DC, you have to maintain the unit to this standard. Oh, lots of questions. All right, so let's do this. We'll go around. So yes, ma'am.
Process where the landlord says the tenant created the hole in the wall, the hole in the carpet, basically destroyed the property. I mean, what's the process for the landlord to rebut?
So the question was, what happens on the landlord side if the landlord believes the tenant caused the problem? We'll get into that a little bit in the eviction section, and as a general rule, the Office of the Tenant Advocate advises tenants. So all of our advice is tenant friendly. If a landlord believes a tenant caused a housing code violation, they could take the tenant to housing conditions calendar. I've actually seen it happen more in a hoarding situation where the landlord doesn't want to evict the tenant. They just want the housing code violation abated. So they take them to this court where the tenancy's not on the line, but there's a judge and there are resources where they can help the tenant make the repairs. But also with DCRA inspections, when they come out, they have to determine whether the housing code violation is landlord caused or tenant caused. So if the DCRA inspector comes out and says, the tenant caused this hole, then it's for the tenant to fix, not the landlord. All right. Yes, ma'am, in red.
Should you, if you're the tenant, should you withhold your rent if there's issues, significant issues with the property?
All right, so the question here is about rent strikes. So it's a popular concept in like the population, is that if the landlord's not making repairs in a timely fashion or there are significant severe repairs needed, that a tenant can withhold rent. Our office never advises tenants to withhold rent because at that point your tenancy is on the line. Your landlord can take you to court for non-payment. What we advise is to use the proactive options like DCRA to get the inspection or going to court to force your landlord to make the repairs. That's our advice. Yes, also in the back.
Do the housing codes apply to private, like single-family housing? Like if it's a house that rents out rooms, 5 units, whatever, do they have to also follow these housing codes?
So the question was, does the housing code cover single-family homes? The answer is yes, it covers all rental property, single family, 2 to 4 units, 5 or more, all of it. And then, yes ma'am, in the striped shirt.
The maintenance violations and all, it deals more along with health, like the lead-based thing. Is there anything that can address synthetic marijuana in older properties where, the juice come up from the floor, from the medicine cabinet, you name it?
All right.
On the right, on the left, wake up dizzy, disoriented. So I'm saying, I know lead-based is like health-related. I need to
Interesting.
know, what can be done about that? Can it be on the landlord to maybe upgrade an older building, the building I lived in was built in the late 1700s?
All right. So this question is complicated in particular, but I'll repeat it. The question was, if you're in an older building and you have fumes coming up from another unit, so they could be synthetic marijuana, it could be smoke, it could be anything. And the question is,
You actually light it. It takes a while for you to focus.
yes, and the question is that a housing code violation? No, because it's hard for the inspectors to sort of regulate fumes. Like, it's hard to document. Might there be some other landlord-tenant protection? Perhaps. And for that tenant, we'd say, come see us. We'll try and come up with something creative because the law just isn't there. Like, there's no statute or regulation on that point.
So when
So,
you say come to us, that's
the Office of the Tenant Advocate.
okay.
Yes. So, yes, ma'am.
But isn't it
Oh.
under federation?
Do you mean federal law?
Yes, that you cannot, even medical.
Oh, you're talking about whether marijuana use is legal.
Right.
So that's a question we'll get to in eviction, so we will get there. Yes, ma'am, in the brown shirt?
Back on the rent strike
The first question was about putting rent into escrow accounts. The short answer is informal escrow accounts don't protect the tenant from being taken to landlord-tenant court for an eviction for non-payment. The landlord-tenant court has a court registry where tenants who are in landlord-tenant court at risk of eviction can pay their rent into the court registry. And you said you had a second question?
The second question is, if you're a landlord and you're trying to fix a housing code violation, and the tenant is unable to provide access to the property because of a busy schedule or what have you, what type of protection does a landlord have?
So the second question was about landlords and whether a tenant must provide them access to the unit to make the repairs. The short answer about that is that the landlord has the right to enter the unit. I'm not sure if it's one of our slides. If it isn't, you have to give 48 hours written notice. You do not require permission. You should have keys. So that the DCRA doesn't give special leeway for a landlord not being able to enter. If your tenant has taken you to court, the court may then talk to the tenant about providing access at the times that you all have agreed to, just as a way to get things done. I have a couple questions up here. Yes?
Now, a quick question. When did this business of late fees get started? And is this prevalent in most rental places? I find it's legitimate, the percentage, which is very high. It's pretty disgusting, but I don't know what one can do with it.
Okay, so late fees we covered in the first half. The short answer is the law passed on late fees happened at the end of 2016 because there was a discrepancy between what courts did with late fees and what the general practice was. So it was that a tenant could only challenge a late fee if they'd been taken to landlord and tenant court. So what we did is try to clarify that with legislation. So now the legislation says there's a cap of 5%
Yeah.
and that a tenant cannot be evicted for late fees only.
But do all landlords charge late fees or just some?
That's gonna be based on the lease. The question is, if the landlord does charge late fees, it's capped at 5%.
Yeah.
Did you have a question?
On the code violations.
Yes.
Do you have to be a tenant in the building to report code violations?
The question was, do you have to be a tenant in the building to report a housing code violation? And the answer to that is yes. And the reason is that the person who reports the housing code violation has to have the right to let DCRA enter or the inspector from the court enter the unit. And your neighbor just doesn't have the right to let people into your house. And then the last one in the back, and we'll move on.
So this is a little bit tricky, but does the Stewart really said, does DCRA have the purview to, so say I'm living in an apartment and I know that the one next door is now vacant, they moved out middle of the night, but it's horrible. You know, it's peeling lead paint, bugs, rats, God knows what, but I can't necessarily prove it for my unit. Do they have the right to go in and check?
DCRA has the right to issue like an administrative subpoena, I believe it is, to enter into any unit. They just don't usually exercise it. They say, we are stretched, there are a lot of tenants, we'll go where a tenant calls us to go, and the tenant has the right to let us in. So if you know the vacant unit is terrible, DCRA, you can try calling them to report like a vacant unit that's not being kept up. And they have their own powers as far as that goes, but it's not really a landlord-tenant issue.
One last thing, does that stretch to that what you just said, the right to go in, would that stretch to the proactive inspectors?
The question was DCRA and proactive inspections. DCRA does do proactive inspections on buildings. They usually work with the landlord, and the landlord identifies units and asks the tenant for permission to enter. So the landlord usually picks units that are nice and tenants who are cooperative. So they don't really run into the issue where DCRA has to force their way into units. All right, moving on, relocation. The tenant has the right to receive relocation assistance in only limited circumstances. And so that's when a tenant or landlord has filed a petition for substantial renovation or rehabilitation. And that's only going to happen in your rent control buildings. If the building is going to be demolished, and the discontinuance of rental housing use. And each of those is also an eviction action where the landlord has given the tenant a notice to vacate with a set amount of time The tenant has the right to challenge them, and that's how relocation assistance works. Yes, in the back.
It was a fire, and I have to go somewhere.
Oh, you asked the $1 million question. All right. The question was, what happens if there's a fire? Does the landlord owe relocation assistance? By statute, there's nothing requiring the landlord to pay relocation assistance. However, what happens if there's a fire and the tenant is displaced by order of DCRA or the fire department? The unit gets closed, the tenant does not have to pay rent until they are returned to the unit. They have an absolute right of return once the unit gets repaired. However, if the landlord pays for relocation or like arranges for the tenant to stay in another unit at their property, the tenant is then still responsible for rent, but their regular rent, the rent that they were paying. So it's one of those, it's complicated.
So,
Yes.
so if the cause of fire was due to negligence on the part of the tenant, do they require the tenant to have tenant insurance? You know, if so,
The question was, what happens if the fire is caused by the tenant? And the answer is the law doesn't specify what happens when it's tenant caused versus landlord caused. It just has these rules that if the tenant's displaced by fire or government closure, they don't have to pay rent until they get to reoccupy the unit, and they have an absolute right of return. The landlord may have other actions against the tenant, but for that, I'd say talk to the housing provider ombudsman or a landlord's attorney. And the other question was, are tenants required to have renter's insurance? It depends on the lease. In your lease, you can require that tenants have renter's insurance. We encourage tenants to have renter's insurance because it is relatively cheap. But it means if there's a fire, if your house gets broken into, if somehow your personal property is damaged, you can put in a claim and get reimbursed for that. You can put in a claim and they might put you in a hotel, like while everything's being sorted out. So you're not at the mercy of your landlord's whims. And then, yes, ma'am.
Thank you. So if the fault of your displacement is theirs, they carelessly caused a pipe to break, are you responsible for paying for the hotel that you may have to go to?
So you may have to pay up front and then sue about it, but that's sort of the American system, is that if someone has harmed you, you may have to mitigate, that means take care of yourself, but then you get to sue them for damages.
Okay.
All right, next slide is on quiet enjoyment. Quiet enjoyment is the right to be left alone. It's not just about noise. So the landlord must make reasonable efforts to address disturbances caused by other tenants in the building. The landlord may make any necessary repairs, but not unreasonably interfere with the tenant's quiet enjoyment. One of the new laws that got passed this February was that the landlord can enter the unit with 48 hours notice. They're supposed to come between 9 and 5, Monday through Saturday, but not on Sunday or federal holidays without the tenant's permission. So this is a wide latitude, but the landlord's only supposed to come for a reasonable purpose, which is usually repairs. Or if they're doing like an annual inspection. All right, and then landlord may not pressure a tenant to vacate the unit, and we'll get to that a little bit in the next part.
Excuse me, what did you just mean about an annual inspection?
Oh, some landlords do annual inspections to make sure that if there's any repairs that need to be made. So I'm checking to make sure that the windows are still opening, that there's no cracks in the ceiling, that there's, like if there's a leak, maybe the tenant didn't catch it, but I did, like that sort of thing.
Is this common?
It depends on the landlord.
Can a landlord come more frequently than a year within the law?
They have to give 48 hours written notice to the tenant, and they have to have a reasonable purpose. So you can't go to the tenant's apartment just to go. Like, it's one of those things. So it's very fact-based. What they're looking for is, are you harassing the tenant, or do you have a reasonable business reason for being in there?
So what's your recourse if they seem to be harassing you?
So this is where it's not the best. If your landlord were to come to your apartment without giving you the 48 hours written notice, in an extreme case, you could call the cops and just say they're trespassing. Less extreme, you can write them a letter saying you may not be aware of this law because it is new, but you're supposed to give me 48 hours written notice. If that still doesn't help, then you can go to DC Superior Court and ask for a restraining order that says, my landlord can only come to my apartment under these circumstances. It's just, the judge isn't gonna wait at your house to make sure your landlord doesn't violate. It's one of those. In the back, and then we kind of have to move on if you want any time for evictions.
So we have something in our lease that
Yes.
says, if you give us a work order slip requesting service, that you're giving us permission to come in and do stuff to wait 48 hours?
So what the law says is yes, you're still supposed to give them the 48 hours written notice, but it also says that the tenant can agree to something less. So if you and the tenant, or in the lease, it says if you put in this work order, you're giving us permission to enter, then that can be enforceable. All right, and then one last question on this. Yes, ma'am?
Should the landlord regularly come in to check the apartment to make sure everything is working properly? I mean, there have been periods and years, I haven't seen my landlord at all.
So the question was, should a landlord regularly inspect the property to make sure that it's okay? Quite frankly, it's a business decision. So if you're a landlord, this is your investment property, I would say common sense says check it out, make sure everything's okay. However, if you're the tenant, your recourse is, if something's not okay, you get to call DCRA, you get to go to the housing conditions calendar. If everything's fine, do you really need your landlord to come by all the time? It's a rhetorical question. Next up is discrimination. So DC has stronger discrimination laws than a lot of places. We have 19 protected trades. We have a list of them right up here. Some that you may not have heard of or thought of: personal appearance, political affiliation, family status. So you can't be discriminated against because you're married or because you're not married. Matriculation, you can't be discriminated against because you're a student. So there are some unusual ones. One of them is source of income. So just be aware, if you are a tenant and you believe that you are being discriminated against because you have or you belong to a protected class, what you would do is file a complaint with the Office of Human Rights. They're an agency in DC government, the complaints are private. They have a process where first they try to help you guys work it out. If you can't, then they investigate and take appropriate steps from there. Yes?
So if my name is Nino Brown and I sell all sorts of drugs out of my apartment, I still can't get evicted because of that?
No, the question is, the question was, if my name is Nino Brown and I'm selling drugs out of my apartment, does that mean I can't be evicted? Well, the part that no one cares whether your name is Nino Brown, John Smith, Juan Valdez, what they're asking is, what is the problem? If the problem is you're selling drugs, that's a violation of the law, or maybe have a drug haven, those are grounds for eviction that are separate and apart from a person's having one of these protected trades. In the back?
Can I, as a landlord, can I just say, I don't accept, I don't like the way they pay in Section 8, so I don't take vouchers?
No, not in DC?
I'm not saying no to the...
Oh, sorry, the question was, for the people at home or once we transcribe this, is as a landlord, can I just say categorically, no Section 8? Because I don't like the way that Section 8 pays the rent. The answer is no. It's very clear. It's not even, there's no gray area. If it's just because it's Section 8, no, because that's source of income discrimination.
So same thing with rapid rehousing?
And then the question was, does that also count for rapid rehousing? Yes. The answer is no, you cannot discriminate. You can't say, I don't accept rapid rehousing. I don't accept Section 8. All right, and then evictions. So this is the last section that I'm going to do. In DC, this is another place where we have very strong tenant protections. You can only evict someone for one of these 10 reasons. For all of them, you have to take the person to court. So your landlord cannot change your locks. They can't put your stuff out. They cannot self-help evict you. They cannot turn off your utilities. If they want to evict a tenant, they have to have one of these 10 grounds. They have to provide the appropriate notice. And then after that notice period runs, they have to file in DC Superior Court, landlord-tenant branch. The landlord-tenant branch has to have a hearing. If they find in landlord's favor, the landlord still doesn't get to change the locks or put your stuff out. They have to wait for the U.S. Marshals to schedule your eviction. So all of those things happen. That is how DC protects tenants against eviction, because they're saying there's going to be a court process, you have the right to be heard, nothing's gonna get railroaded through. Reasons why you cannot evict tenants in the district. These are my favorites. You can't evict a tenant because you don't like them anymore. You can't evict a tenant because it's the end of their initial lease term. In DC, they automatically have the right to go month to month under the same terms of the initial lease, but the rent might be increased on a 30-day notice. You also can't evict a tenant for foreclosure, and you can't evict a tenant just because the property is being sold.
Can you elaborate?
Yeah, I figured y'all might want that, so.
Three up, and then the last one, the one about when the lease
This.
ends, and if their lease ends and they might want to go month to month, but you might not want to.
You don't have an option, because that's DC law. DC law says that the tenant can go month to month. You can offer the tenant a new lease, they just don't have to sign it. And it's that straightforward.
Oh, there's a
They do
lot.
not have to sign a new lease, they can stay month to month. If you're an exempt property, exempt from rent control, sometimes tenants like to sign a new lease because they can lock in the lease rate for the next year. But that's really their only motivation.
Just want to know what's the vacated.
Oh, sorry, let's go around this way. Yes,
Yeah, in
sir.
regards to the eviction, all of the above applies to occupancies. Occupancy,
Oh.
not so much as just tenants, right?
No, so DC makes a distinction. Tenants have tenant rights. Tenants have protections against evictions. Occupants have fewer protections. If you were a landlord, and I was advising you, which I wouldn't, I would say, take them to court anyway, because that's gonna be the easiest process. That way you will not be sued for wrongful eviction by self-helping. But tenants have the right to only be evicted for these 10 reasons. Non-tenants, that is like a box on the landlord-tenant form. This person is not a tenant. Okay, and then I had the lady in the green sweater.
Yeah, I actually have two questions.
Yes,
The first one is back to the rapid rehousing issue.
yes.
A number of landlords will not take the rapid rehousing voucher because the rapid rehousing comes in with 3 months funding or 6 months, and you're looking to sign them to a 12-month lease agreement. And that's why the rapid rehousing is not accepted.
So the question was about rapid rehousing. And they said some landlords don't accept it because rapid rehousing only agrees to pay for 3 months or 6 months and the lease is for 12 months. Unfortunately, that is not ground. The law says you cannot discriminate against a tenant because of their source of income. So you say, but what happens at the end of the 6 months? What if the tenant can't pay? Well, you could get a tenant who has a great job, great salary, and then 3 months in, they get fired. If you still had, they met your qualifications, so you rented to them. Situations change, things change, but you cannot discriminate based on source of income. Yes, ma'am.
I think, that whole issue plus the housing choice voucher, and I don't want to take a whole lot of time, but it bears a lot more discussion. During the day, I help clients find housing. Most of them have vouchers or rapid rehousing, and we see all sorts of ways that landlords are using it, but they just flat out say no. So I think, and we're about to roll out more rapid rehousing and more local rent supplement vouchers, so this is gonna be an even bigger issue, and I just think there needs to be some more discussion.
Yes, and so the comment was that there needs to be more discussion, sort of district-wide, around renting to people who have rapid rehousing or having choice voucher or the local rent subsidy or supplement, I think is what it is. And that's true, because I think we need to get the word out to landlords that you can't discriminate, and we also need to encourage tenants to report discrimination to the Office of Human Rights, because they have no problem going out there and talking to people and letting them know you can't do this. And sometimes they do, they're not sting operations, because that makes it sound super covert, but they will go out and they'll test to see if certain landlords or certain buildings are habitually doing this, and then they can take action on that front. Sir? In the back?
So it just seems to me if someone comes in and says, I want to rent your apartment, I've got a job chopping wood for 3 months and then it's over, that you'd be like, well, what are you gonna do after 3 months? I gotta know or I can't rent you. So the same thing with, that, I think, that's 3
Except
months.
it's a source of income discrimination, and if that person wanted to file against you in the Office of Human Rights,
Not the source,
they
the
could.
land.
It's a source of income discrimination. They're saying if the person meets your standards, which means income including the subsidy, then you have to rent to them. Like, that's all it's saying. You can have your credit checks, because that's not a protected class. You can do all sorts of things, but source of income, you can't discriminate against. So I would like to move on to make sure we get through all of evictions, but I'll take this last question. Yes, ma'am?
All right, I wanted to speak about this Section 8 thing. I didn't know that Section 8 was coming out of taxpayers' dollars. And
Oh,
so
ma'am, well, that's not what this
what
presentation
I
is
was trying to
about.
say, a lot of people be looking at people that have vouchers and discriminating, just like what happened to me, what that lady said. And I knew she was lying, but what I was going to say, why are they mad at us when we give vouchers? Section 8 had no business introducing vouchers in DC. We had rent control. It was affordable to be paid by me. They the ones that brought it to the table, then the owners get in here and get greedy with it. I want
So
2,000.
this is another comment saying that
Yeah.
people should not discriminate against Section 8
Yeah,
holders,
because-
and we absolutely agree.
You absolutely right, because I used to work 2 jobs, and I paid into taxes. I didn't know, nobody ain't asked us to vote on that. We didn't know that they were using that particular money for Section 8. So when I have a voucher, they be looking at me all funny and everything, and lying and everything. And that's my money, they probably get loans to redo the property, loans off of our tax dollars, people that
All
work
right.
there. All
Well,
right,
thank
that's
you,
it.
ma'am. That's my time, and now I'm gonna hand it over to Zach. Here you go.
All right, thank you, Ramona. So, hopefully, if you have other questions, hopefully we'll have a couple minutes at the end, because I know that there were some other hands that Ramona wasn't able to get to. But we're gonna start up with retaliation. In DC, any retaliatory action is tenants will be protected, and what that means is if a tenant voices essentially any legal right they have under DC law, whether that's requesting repairs, contacting a government official, or really anything that either the lease or DC law protects them, the landlord can then not take action to retaliate against them. They cannot give you a rent increase that they would not give to you otherwise if you didn't request repairs. They cannot, if you're in an exempt unit or even in a rent control unit, they cannot say, we're not gonna renew your 12-month lease, we're gonna force you into month-to-month at some sort of higher rate. They have to treat you the same way that they treat everyone else who has not voiced their right under the law or created a tenant association or any of those things that they're protected from. Retaliation, when it comes down to it, is sometimes difficult to, verbalize, because it often is a when you see it type of standard, and they have to almost have a malicious intent behind their action, because if they have a legal right to do it, so if you haven't been paying your rent, and then you request repairs, if the rent started before the repairs were made, then they can still evict you for non-payment of rent. It's not going to be retaliation if there's a legal basis for the action the landlord takes. But if you are getting either disparate treatment, or it is based solely on that action that you have taken, it would be prohibited retaliatory action. Did you have a question in the back, ma'am?
Yeah, I'm in a catch-22. Whenever I make a complaint, my rent goes up.
Yeah, and
And I've been reluctant to make complaints about certain repairs because I have a month-to-month lease. And it's really getting to be expensive, and I live in an older condominium building that I rent from the owner.
yeah, and so just
What
to,
recourse do I have? I mean, what kind of evidence would you need for retaliation? Just proof that you have a lease, and the lease is $100 more a month?
and just to repeat her question in case you didn't hear it, the question was specifically, I'm on a month-to-month lease, and I believe that my landlord is increasing my rent whenever I make certain requests for repairs, and it makes me hesitant to make those requests, and what sort of recourse is available to me. There's retaliation you can file what's known as a tenant petition, A tenant petition is an administrative complaint that you file with the Department of Housing and Community Development, DHCD. And it's one of the few things that you can file at DHCD with a tenant petition, no matter whether you're subject to rent control or not. The one downside of a tenant petition solely for retaliation is that you, the tenant, do not get money. What happens at the end of the day is the landlord can be liable for a fine of up to $5,000 per violation. So if you allege that your landlord had 6 violations, your landlord could be fined up to $30,000, because it'd be $5,000 per retaliatory act. And so your recourse is to file that tenant petition with the Department of Housing and Community Development. It's a free process, it's a very straightforward process, and you would file that as we've mentioned a few times today. It's 1800 Martin Luther King Avenue, Southeast. It's right in the corner of Good Hope and Southeast. Follow-up question, yes ma'am?
Yeah, I forgot to tell you that I've been living in this place for 12 years, and things are starting to wear out. Like the dishwasher stopped working. Okay, and then I asked for it, and I have to wait like a year and a half before I get the dishwasher fixed. And then come September, when my lease ends, it goes up a significant amount of money.
Right, and just to repeat again, she said that it took a year and a half to fix the dishwasher, and then when her lease came up, that there was a significant rent increase despite the delay and the housing conditions issues. If you're subject to rent control, within that same tenant petition, you're not subject to rent control. Okay, so just for those who are or aren't, it kind of came, Ramona touched on this briefly. If you're subject to rent control, you can file the tenant petition for a reduction in services and/or facilities. If you're not subject to rent control, then you would have to file that, most likely it would be in small claims court. If you're seeking less than $10,000, you can file seeking a refund of the rent you have paid to say that landlord didn't hold up their end of the bargain and give me a unit that is 100% in compliance with the housing code, so I should not be responsible for 100% of the rent. And you can seek a partial refund of the rent you have paid, and that would be through most likely the small claims court process for under $10,000. Okay, moving on from retaliation, we have the right to organize. In DC, every tenant has the right to organize protected. Landlords may not interfere with those rights. Now, the landlord is not obligated to promote a tenant association. They're not obligated to give you meeting space or those sorts of things. But if they do have a designated community board, they have to allow the tenant association to post on there just as they would any other organization. And they're not allowed to prevent you from handing out flyers to other tenants. Now, they can prevent you from posting them anywhere in the building that you want or posting them on the doors of your neighbors, but they can't prevent you from handing them out to neighbors or sliding them under the doors in ways that don't affect the way that the building looks. And similarly, distribute literature, post information, convene meetings. They can't actively interfere with any of those things.
Excuse me. So can you only do those things to a member of the tenant? In fact, if you are representing with your literature the tenants association, can you only slip under the doors of tenant association members?
So in theory, you can do it to any tenant in the entire building, because it's not just the tenant association that's protected, it's your right to create or organize an association, and whether that's the one that already exists or whether you're trying to create another tenant association in your building because you don't like the one that exists.
Or combat a particular violation of the landlords?
Yeah, if you're trying to organize to help, all that stuff would be protected.
Thank you.
Next up, yes sir.
What is the conventional wisdom of the landlord attending a organized meeting?
And so you can't force your way into the meeting. If they allow you to attend the meeting, if the tenants have the option whether or not they want to allow the landlord or landlord's agents attend the meeting. Sometimes landlords wish to attend because they want to hear what the tenants are complaining about and help rectify those issues. But the tenants do have a right to hold a closed door meeting to only members of the tenant association. And that could happen either on-site if you do provide them a meeting room that they have properly reserved, or it could happen off-site. A lot of times they hold it at local libraries or things like that.
The tenants have a right for a closed door meeting?
They do, yes. Yes, sir.
If the building owning entity is a condominium, and the building goes up for sale, but it's a rental property, just the owning entity is a condominium. Is there another way to serve those tenants? The notice, can you give each individual tenant the right to buy the entire building as opposed to giving them the right to form?
And so you're essentially saying that one entity owns multiple condominiums owns multiple or all of the condominiums in the building?
Yeah.
So if it is listed as separate, if there's, legal
Separate
title
tax.
is separate, then each individual unit you would have to give individually to each tenant, and they would be treated as single units. We could talk about that later, but that's my understanding, is that if they are separately deeded, then the individual tenants have the right to buy their individual units for TOPA.
Yeah.
Are we talking about TOPA or
Yeah,
conversion?
TOPA.
Okay. All right, we can talk more about that afterwards. Yes, sir?
What about co-ops? How would this apply to co-ops?
And so, we're talking about the right to organize?
Yes.
So co-ops are not actually subject to the rental housing law because co-ops are a membership of owners. So they don't fall under the same tenant rights. Now, there are a number of co-ops in the city that are either mixed where the co-op may rent and have members as well in the same building, or there could have been a co-op that was established that for some reason membership has dissolved and the co-op is just an entity that owns and they just strictly rent to everyone. Sometimes that occurs. And if that's the case, the rental tenants are treated with the same protections under the Rental Housing Act. But if you are a member of the co-op, you're not provided those protections. Yes, sir, in the back?
So if I want to start a tenant organization, do I have to invite every tenant in the village to join?
No.
Just one?
So tenant organizations are freely formed and freely organized. You could certainly open yourself up for liability if you were discriminatory in the way you invited people, if it was based on a protected class. But I haven't seen that, and almost always they allow everyone in. And it depends in certain circumstances when it comes to TOPA and conversion, and some of those, the law sets up how people can vote and how those things occur. So it may affect the way you would want to organize your tenant association, because by purposefully excluding people, it could hurt your ability to vote for the way you want, because even if your organization votes one way, you still may lose if those who aren't members don't. Ms. Davis?
And what about the dues?
All of that is freely negotiable, so that is up to the tenant association board, and it has to be governed by the bylaws that created the tenant association.
And they can, pick and choose and raise the dues anytime they get ready?
Yep.
We have a tenant who is also an employee of Dara Management. And that tenant is insisting that he can come to the Tenants Association meetings because we, in our bylaws, did not say that any tenant who lives here who is also an employee is not invited to the meetings. Is that true? When he comes, we hold our meetings in the lobby. We hold our meetings in the lobby. At our next meeting, if he appears, do we have to accept him?
And so, not to get into the specific questions, but in general, the bylaws govern. So what happens with tenant associations is tenant associations are supposed to form a corporate entity and supposed to register with the DC government. And whatever bylaws you have, just as if you were McDonald's, you follow your bylaws, or else the members of your corporation can bring an action against the board. So whatever your bylaws require is what you, as a board member, or whoever is the board member, are going to be obligated to. But when it comes to certain actions in TOPA, as well as the conversion process, as was mentioned, employees don't have the same voting rights. Yes, ma'am, in the middle?
Hopefully I can just piggyback off of another question. If you and, say, maybe a very slim majority of tenants want to purchase the building under TOPA, but you're already aware of tenants who are strongly against it. So when you go to initially form the tenant association, are you by DC law, federal law required to open that organizing meeting to form your tenant association to every tenant in that building, knowing that vote could go one way or the other? If you are taking advantage, or you take the initiative to call
And
our
so-
counseling agency to get the process started. Are you by law?
And so the question is, by law, are you required to allow everyone to join your tenant
Every
association?
tenant,
Every tenant to join your tenant association for a TOPA matter. TOPA specifically defines so TOPA in a 5 or more, we're gonna get to that in a moment. The tenant association is the one who holds the right to purchase. Individual tenants have no rights in a 5 or more. And for you to be the tenant association that holds that right, you have to represent more than 50% of the tenants in that building. But there's nothing specifically that says that everybody has to be involved, or that more than your 51% have to be involved. It just specifically says, to be that tenant association, to hold that right, to be able to respond under TOPA, you have to have a majority of the heads of household as members of that tenant association. Yes, ma'am, in the green?
If there's federal dollars on that property, then, and you're receiving funding from HUD for your tenant association activities, you are required to open up participation to any tenant who's living on the property.
And HUD properties are completely different, and usually that's a resident council as opposed to a tenant association that receives that HUD funding. And resident councils do have much more open access.
I just wanted to clarify that if
Yeah.
there's any federal dollars on that property, you need to really look into it a little bit more before you start picking and choosing friends.
Yes, and that's exactly right. And a lot of times I've seen instances at sort of HUD subsidized properties where there are competitions almost between the resident council, which is a regulatory body that is created in a lot of these, and the tenant association that someone separately created because they were the former president of the resident council, or they weren't allowed to be a board member of the resident council, and it gets very messy. It gets very, very messy. But resident councils are much more regulated than just a traditional tenant association, which can be freely created and joined.
One last question, please.
Mhm.
This is not TOPA related anymore. We have a tenants association, TOPA is long in the past, basically. But we have again, a Darrow employee who is also a resident. We really don't want him coming to our meetings because there's still lots of contentions. Our bylaws do not say that we can deny.
And if your bylaws don't say that, you cannot act outside of your bylaws. You would have to vote to change your bylaws to exclude people who are non-members, or people who are employees, or former tenants, or whatever. You can change the qualifications for membership. Okay, next up is conversion. Conversion is something that is not as common as it used to be, but condo conversion it's essentially the conversion of any rental housing into a co-op or condominium. It still happens a lot, but it was kind of really impasse, at least this is what I'm told, because I've only been doing this for 5 years. But so for condo conversion, for rental housing or co-op conversion, it needs to be put up to a vote by all the tenants, all the heads of household for the tenants in the building. There are special protections for those tenants that are elderly or have a disability, and they can be promised sort of a continued tenancy, but if they choose and elect for that continued tenancy, they're not allowed to vote in the conversion process. So in the conversion process, you can actually lose your house, you can be evicted because of the conversion. So if you vote in favor of the conversion and you decide not to purchase the condominium or become a co-op member, that is one of the grounds for eviction that Ramona talked about earlier. It's pretty infrequent because as a way to incentivize you to vote in favor of the conversion, almost every deal they give you the 3-tier system where you can choose to be a continued tenant, you can choose to purchase the unit, often at a discounted rate, or you can take a buyout to move out. And they sort of work out these deals or development agreements prior to the conversion vote taking place so that they know when they go file the paperwork with the rental conversion and sale division, they know exactly how it's going to play out because they have your votes ahead of time.
That's 70% to do that?
So it's 70% for a voluntary agreement. A conversion only takes a majority. And so as this says, it's really tiny on this screen, majority of eligible tenants, and by tenants here they actually mean heads of household, and they designate in the law what a head of household is. So it's only 1 vote per unit, it's not how many people are actually living in your unit. And the district's conversion and sale administrator certifies the election. Currently, that position is vacant, but we'll just ignore that. Because Lauren Pear, who used to hold that position, now became the rent administrator. She's doing both right now, so she's handling a lot, but that's what's going to be, occurring next. And as I mentioned, as you'll see on here, elderly or tenants with a disability, if they meet, there is a low income requirement for that. They can essentially be guaranteed lifetime tenancy, even if they're not given that offer in a negotiation, which often they are. Yes, ma'am.
Can I ask you, somebody ran this by me while I was here today. Cash for keys, what do that mean?
And that's when I mentioned that there were often 3 different scenarios that could play out. The right to continue as a tenant, the right to purchase, or the buyout. A buyout is a cash for keys agreement. And cash for keys can happen in more than just condo conversions. It can happen to avoid eviction. It can happen if they want to sell the property. Cash for keys means someone is going to give you an amount of money and you're going to turn over the keys and relinquish your possession of the unit to terminate your tenancy. And sometimes it can be very beneficial to tenants and it can be quite lucrative. Other times it's less lucrative, but could still be the right situation for you. So sometimes your landlord, as we, some landlords didn't know that essentially when you sign a tenancy in DC, it is almost indefinite. So when you go month to month, if they determine that, we don't actually want to rent anymore, I'll give you $500 to move, you can choose to accept or deny that offer. And if you accepted that, that would be cash for keys. You would give them your keys and say, I'm moving out at the end of the month, and they'd give you $500.
When they started a Hope tenant association over there where I live, but they gave that lady $50,000.
And
So I'm saying,
sometimes,
where she get that money from? So somebody said, cash for keys. She sent there all the tenants $25 gift certificate to Walmart. That was this last year, not this year. So that's why I was wondering about that.
yeah, there's a lot of different factors that come into play as to how lucrative, that determine how lucrative it can be for the tenants. And sometimes I wish that I was the one living in those units because they can really make it worth your while. Especially if you're the last tenant in a building that's almost vacant, you really wish you were in that one.
Yeah.
Okay,
So I might be in good shoes and don't know it.
you might be. Maybe you're getting an offer
They
tomorrow.
were trying to convert, she went with the TOPA thing, they was trying to convert
Yep.
and everything. Now they renovate while we in and move you out, move you into another unit, move you back. That's crazy.
Yeah, it really is.
I said I wanted to go. I don't want to move out, move back in.
Right. Okay, next up is TOPA. As you can see, this is the only slide on TOPA, so we're providing you a lot of information. But really, TOPA is hyper-technical in some instances. The reason that this slide doesn't have a lot is because usually we try to do this presentation in 2 hours, but we knew that there were going to be lots of questions. We just didn't add any more slides. But so TOPA is the Tenant Opportunity to Purchase Act. It had, any time that there is a sale of rental property in the district that is occupied by a tenant, you have to give the tenant what's known as the offer of sale. There's 2 different types of offer of sale. There is Form A, which is the offer of sale with a third-party contract, and Form B, which is the offer of sale without a third-party contract. Both Form A and Form B come in 3 different versions because TOPA is viewed, the law categorizes TOPA into a single-family unit, which applies to a single-family house or a row home or a condominium, a 2 to 4 unit property, and a 5 or more unit property. And depending on which category you're in, there are different timelines and different responses that the tenants have to do. In a single family property, when you provide them either Form A or Form B, depending on whether or not you have a third-party contract, meaning you've accepted an offer, or if you have not, you just are putting it on the market and want to get the process started. In a single family, they have 30 days to respond with a statement of interest. If they do respond affirmatively with a statement of interest, that puts them into the negotiation period, which is 60 days. In a 2 to 4 unit building, for some reason, it's less time, even though it's more complex. They have 15 days to respond jointly within the building. So if it's a 4-unit building, the 4 units can respond jointly in the first 15 days. If there is no joint response, you then have 7 days to respond after that as an individual. So you get 22 days total if you're an individual and want to respond. I don't know why that's less than single family, it makes no sense. 5 or more, you have either 30 or 45 days, depending on the situation. If you have a tenant association in place when the offer of sale is presented, you have 30 days to respond as a tenant association, whether you want to submit, respond and submit your statement of interest. If you do not have a tenant association formed when the offer of sale is presented, you get an additional 15 days to form your tenant association before the 30 days to respond. So you essentially get 45 days to respond with your statement of interest, saying we intend to purchase or we intend to explore the option to purchase. For all of those, you enter into the negotiation period. By the end of the negotiation period, you have, as I mentioned, it's 60 days, you have to finalize a contract to purchase the property. In some instances, that's not you, the tenant, or you, the tenant association. That's whoever your assignee is. So you can assign your right to anyone else. And a lot of times, this is where you get some lucrative deals as well, where there may be another developer or a family friend or someone you know that wants to purchase the property, and you can assign your right to them, and they can purchase and step into your shoes and have your legal rights. And so that group would have to enter into the contract by the end of the negotiation period. If they do, you then go into a financing period where the tenant has the time to formalize, to go to the banks or whoever they're trying to get their financing, and then they can finalize and proceed to settlement. So that varies as well, but it's typically 90 days for the financing period, and then you have to proceed to settlement after that. Yes, sir, in the back?
Can that assignment of your rights be done at any time, a year in advance, 2 years
No.
in advance?
You cannot waive your right to TOPA. The law is very clear, so they do not allow any waiver or assignment prior to being provided the offer of sale. And so any sort of pre-waiver, so we've seen things before where it says in the lease that landlord intends to sell this property at the end of your lease, and by signing this addendum, you are waiving all your rights to TOPA. It's going to be unenforceable. So you cannot in any way waive your right to TOPA prior to being provided the offer of sale. And even then, it's technically not a waiver, it's just a declaration that you're not exercising your rights, or it's an assignment back to the purchaser, which is also a common way. So you essentially close the loophole and tie up the loose ends. So if Ramona is the seller and Harrison in the back is the purchaser, who, Ramona accepted his offer, they give me the offer of sale, they could show up that day or the next day and say, here's your offer of sale. If you are interested in buying, you can do that. If not, Harrison, the purchaser, is willing to give you $10,000 to assign it to him, the purchaser, to kind of close that loophole and make sure you don't assign it to anybody else. Yes, ma'am, in the green?
Yeah, this is up for review, next week.
And so there are a few proposed legislations for TOPA that will affect single-family units or single-family units that have English basements, that legislation is up for review. It's not going to change everything, but it may provide certain exemptions for owner-occupied units, and that typically applies for if the owner either rents out the basement or lives in the basement and rents out the upstairs, or rents out a guest house type of situation. There may be certain exemptions, and there's pending legislation right now. There's 2 different bills that address it in 2 different ways. Yes, ma'am.
I don't know if there'll be much time for further questions, so I want to ask my question now. In terms of security deposits, okay, if, for example, a scratch happened on a wooden floor because some furniture was moved, and so that's a damage, how then is the amount determined that would be deducted from your security deposit?
And this was all covered in the first session.
I was
but
not here.
I understand that, but security deposits it's determined as to what's reasonable cost, and that's it. That's all the law says. So whatever the landlord deems reasonable for required to be repaired, if you disagree with that, you can file a tenant petition, or you can file in small claims court to say that was an unreasonable cost, and the judge will have to determine what's reasonable. Yes, sir?
You said 90 days, it's 120 days.
For which?
It's for the closing period. It's 45, 120, 14, 120.
And so it's for the 5 or more, it's 120. For the single family,
Yes, no, you were talking about the extended period, but it doesn't.
Okay, I apologize if I mixed that up. And so just the closing period is 120 in the 5 or more, it's 90 in the single family.
For Topa.
Are there exceptions to TOPA?
There are a number of exceptions to TOPA, and so it comes into how we define a sale. And so TOPA only applies to the sale of rental property when it's occupied by a tenant. And so what is a sale? The common exemptions are foreclosures. Any court-ordered sale is going to be exempted. So that applies to foreclosures, bankruptcies, tax sales, divorce proceedings that have a court order. All of that can exempt it. Similarly, estate transfers can similarly do it. If the estate opens it up for public sale, that's not exempted. But if in the will, or the last will and testament, it said, I'm giving this to my grandson, even if there is consideration involved, that is going to be exempted. There are also inter vivos, meaning while living transfers, and that applies to family. So if you were essentially anything in your immediate family, grandparents to grandchildren, brothers, sisters, that is going to be exempted, even if there is, again, for consideration. So it can be for money, but that's going to be exempted from being a sale.
Portfolio sale?
Portfolio sale as well. So if it's a single asset entity, meaning an LLC that only owns this property, selling that LLC is not exempted. That is a sale. If you're selling something that owns 100 different buildings, or you're selling a parent corporation that owns 100 LLCs that are single asset LLCs, that's going to be exempted as well. So portfolio sales will be exempted, but again, that gets hyper technical based on the type of sale. Yes, sir, in the back.
Is it, let's say a building's worth $1 million, landlord wants to sell it, he doesn't want to deal with TOPA, so he gets an investor who says, I'll give you $1 million of the loan, and then you just don't pay it, and I'll foreclose on you. Do you think law will protect from that? I would hope so. I mean, that's fraud if you could prove it.
I mean, yeah,
So he's going to get recaptured on his taxes. It doesn't.
Yeah, and so I don't know why he would do that. I think the foreclosure would hurt him, but it's one of those things that, yeah, they could claim fraud and they could file their own. They can contest it in Superior Court. TOPA specifically outlines how to file actions to contest. But yeah, so I don't think it would make sense to do that. Yes, ma'am, in the green?
Yeah, I can tell you what happens. Usually, the new purchaser will get added on or join the LLC of the current ownership. This is the new purchaser. This becomes a partner in the deal of the
I
current
think you can do that, can you, if you transfer more than?
No, it's an expansion of the partnership, it's not a transfer of the
Not
asset.
at that time. They join on and then the other ones will go. That's what happens.
Yeah, and all of those, I mean, if it happens as cleanly as you're describing, that would be a violation of TOPA. If someone comes on and then the other person leaves, then there was a transfer of the ownership interest, and so TOPA would come into play there. Yes, ma'am, right behind you.
Okay, like a scenario for a single family home. And I heard you say something about foreclosures, like example, but if you're renting in a single family home, you're like about 5 or 7 tenants. And it's been foreclosed, and developers and real estate agents are coming around trying to buy your TOPA rights. So you still have TOPA rights if the home is like in foreclosure?
And so while it's in,
And then convert it.
and while it's in foreclosure, the foreclosure, it's a court-ordered foreclosure sale is what's exempted. So they're saying that is not a transfer. But if you're in foreclosure, or you're approaching foreclosure and you're trying to work out a short sale with the bank or something like that, that's going to fall under, that's going to apply to TOPA. And so you would still have TOPA rights. But if you are a tenant in that situation and have specific questions, come talk to us during our business hours and we can review the paperwork and try to have someone answer those questions for you. All right, there are a few slides that we're going to blow through quickly. Moving out, if you were here for the moving in portion, it's the exact same, just opposite. Take as many pictures as possible. That's really the biggest point. Walk through, take as many pictures as possible.